thing on the agenda is petition on contest of primary election, and we will turn that over to our prosecuting attorney, Jackie Stevens.
Well, I mean, obviously everybody's aware that there's been contests filed by Mr. Brumfield and Ms. Harless. And I also am aware that there's been motions to, well, I call it a conflict, disqualify, I call it a conflict, to conflict both of the remaining commissioners that sit, which would clearly, and I don't know what Thomas's position is. Obviously, by statute, Thomas, you're conflicted out of the contest in relation to your race. And I hadn't really talked to you to know, were you going to sit on Mr. Brumfield's race, or because the evidence was probably going to be kind of, I assume, submitted simultaneously. I didn't know if you had a position on that or not.
I will not sit on that.
You will not sit on that because I guess I understand. So I guess then we're already left with just the two commissioners for both contests, and there's been motions to disqualify both of them. Now, I've reviewed the motions, and I've had one conversation with the Secretary of State's office last week sometime. I don't remember exactly which day it was. And all they'll do is talk with me, and obviously they leave it up to me. They say it's not their role to make any decisions, that I am your all's counsel, and so it's for me to kind of, I can use them as a tool, but I have to actually come up with my own opinion. I've looked at the two petitions, and through the discussions with the Secretary of State's office, I think I came to the conclusion that as far as a motion to disqualify, I think probably that runs in, when you're all sitting as commissioners in relation to a contest, you sit in the role as a judge. And the rules in relation to a judge when a motion to disqualify is made is that the judicial officer themselves makes that decision whether they want to file or agree to the disqualification or not. Obviously, they don't agree to disqualification, there's an appeal of that. When it's a circuit judge, the appeals obviously straight to the Supreme Court. The Supreme Court makes a ruling on that, and there's a legal procedure to do so. And it happens sometimes with the judge, so I'm somewhat familiar with that. But Jay's probably a little more familiar with that than I am. So I had that conversation with the Secretary of State's office, and I think that's my position in relation to the actual motions to disqualify both of the commissioners. But I've also had a conversation with Mr. Carey, who represented it. He'd been talking to Mr. Payton, that was yesterday, and that what was being proposed by the lawyers in the case was that they were going to file a joint motion just to have the hearing in front of the commissioners waived, and it be sent up to directly to circuit court. And I believe there is precedent to do so. It was kind of my position that that certainly would be fine with me. But again, I only said as your counsel, and you all said as people who make your own decisions. Now, I mean, you have to make your own decision for yourself about the motion to disqualify. And I said if the two commissioners that the motions were filed in relation to had no problem with that procedure and it being sent up to circuit court, that I would certainly have no problem with it myself. So that's kind of where we stand in relation to that. And then based on the fact that I saw these motions coming, I had a phone conference with Judge Hoke this morning. Because obviously, in relation to if it is waived up to circuit court, obviously it has to be heard in circuit court. And Judge has been gone for a while, and so our docket up in circuit court is pretty well extreme right now. And so I talked to Judge Hope this morning, and he related to me that, first of all, if that's what everybody wants to do, there needs to be some order generated where everybody agrees it's going to go to circuit court, which I think would pretty well, also in my opinion, require agreement from both of the commissioners if they're going to go ahead and disqualify themselves. And then the lawyers for the parties that are filing the contest could file a joint motion with the counsel for the respondents in that matter. And I think at that point there could be agreed order entered, and the case would then be sent to circuit court. So I furthered my conversations with Judge Hoke a little bit into the fact that with our docket, there were really would be two options for him, and I told him I'd get back to him with him after I came to the commission meeting this morning. The two options would be, number one, he could just, obviously this being a very important procedure, he could clear his docket of cases that were of not of such magnitude that they require. We have certain cases by law that just have to be heard, and we would have to continue to do those. But he would be. He would do the best he can to reschedule his docket. Or number two, he could obviously agree to recuse himself, and then judge from another circuit would be appointed or brought in, he did bring up to me that if another judge was appointed, they'd have to find one who also had the ability to do it, because all judges have dockets, and he said, you know, once it leaves his hand, that the Supreme Court then is the one that appoints it, and you know, you get whoever you get. And so, you know, I don't know. I guess probably you know, I think probably in general his position would be that he would sit as the person to hear it, unless one of the attorneys for one side filed a motion to disqualify him, and then obviously he would sit in the same position that our two commissioners right now sit, and he would make that decision for himself. And I have no idea what decision he would make. But again, you know, I've tried to run all the variables and not knowing what's going to happen, so I think I've done as much work as I can, but I think the rest of the decision work's probably in other people's hands, and so I kind of leave it there. And from a legal standpoint, I think that's pretty well where it stands. You know, obviously it's probably not a bad idea, and it would probably be my advice to the commission for the commissioners to disqualify themselves, not necessarily disqualify, but just agree that perhaps the easier procedure in this case is to have it heard in circuit court. That being said, it's not my decision, and I will, you know, after I hear what's going on today, and any time once, you know, if you don't make a decision today, you want to think about your decision, that's fine. But as soon as you make it, and you probably need to report back to me and also to the lawyers, Mr. Payton and Mr. Carey, so they'll know whether they can do an agreed order and send it up to circuit court. And the judge has promised me that he will attempt to get the contest heard. He understands there's a 90-day time limit. It has to be heard within 90 days of May 11th was at the election. So June, July, August 11th or thereabout. I don't follow which months have 30 days and which don't. But so he's aware of the situation because I've made him aware of it, and he's willing to do whatever it takes to get the contest heard if it falls in his lap. So
if Commissioner Banks and I would recuse ourselves from this based upon the petitions being filed, then at the same time pretty much would take you out of the picture too, because you're representing the commission.
Well, yeah. I mean, I would in all likelihood attend, but I mean, again, at that point, both sides are represented by counsel, and I know able counsel. I mean, I'm familiar with both sides' lawyers, and I know they both have lawyers who have as much or probably more experience than I do, in particular in these kind of situations. But yeah, I guess at that point, my role in this is merely to advise you all in legal matters. Obviously, I never would have said it as a fact. I wouldn't be a fact finder or anything like that. If you had a legal question, if there had been a contest in front of the commission, I think it would have been. And I talked to Rich Rife, who was a prosecutor up in Boone County, and he had been through a contest, and he said that's what him and Sam Hall did when the contest was held in front of the commission. They said, and if there was a legal issue, not a factual issue that came up, they would, to the best of their ability, advise the commission on what they believed the appropriate law was. But so I guess to the short of yours, I think at that point, any active participation in the process by me would be over.
Since we have tentatively set next Tuesday at 9:30 to begin the contest, would it be maybe more appropriate to assemble that body, since notices have been sent out, and at that juncture have the decision made either to step aside or just sit?
Yeah, I don't see any problem with that, but I do think that it would probably be best to figure. I mean, I think if it's possible to figure out if we can figure out that's where it's going to go when we meet on the 28th, I think we would be best to go ahead and figure that out so we can get the scheduling. You know, because Judge informed me if such an order's in or conflicting the remaining commissioners out, and that it was going to be heard by the circuit court, he wanted the lawyers to immediately get a hold of him and have a scheduling conference.
Jackie, let me ask you something. If one commissioner recuses himself, the same thing happens. I mean, because there's only one that said it.
Yeah, you know, again, the problem, there's no law as to what that would be. It would be my position there would no law.